Good morning, Facebook. John Nia here, one of the founding partners of Trowbridge Law Group. And I'm here today to talk to you about bad actors, bad boys. Are you a bad boy? uh, there's a rule under Regulation D, Rule 506, D and E. I think those are the rules that cover certain bad actors, certain people that are prohibited from taking part in a Rule 506 offering. So if you are subject to certain disqualifying events, you are prohibited from doing a Reg D offering. That's part of the rules, right? So this came about in 2013. It was actually Dodd-Frank Act that passed the initial rule. I guess they wanted to prohibit certain people that had done bad things in the past from raising money in future subsequent offerings. I guess, part of the whole 2008 financial collapse, the CMBS, whatever crap. There was a lot of bad people out there, bad actors that were doing things that they shouldn't have been doing, and Congress, they didn't want them to be able to raise money privately in the future, so they passed Dodd Frank, and then part of Dodd Frank was this bad actor provision. Um, so now, if you're doing a Regulation D offering, you have to ask yourself a few questions, right? The issuer, the company that's selling the securities, has to go through certain processes to make sure that people involved in raising money aren't subject to these bad actor disqualifications. So the first question you have to ask is, who is a covered person? Because that's going to determine who is going to apply to, who are these disqualifications going to apply to. So if you are an officer, director, manager, managing partner, general partner of the company selling securities, then you are a covered person and you have to go through the next step. If you are a promoter of the issuer, if you are hired to raise money for the issuer, you're also a covered person. And then lastly, if you are an investor who's going to be purchasing 20% or more of the interest in the company, um, calculated on based on voting, right? 20% of the voting power of the company, then you're also a covered person. So something to keep in mind for, companies that are trying to raise money. If you don't have a cap on the amount an investor can invest, an investor decides to invest more than 20% of the capital, this person might be subject to the bad actor disqualifications. And then he's going to have to, go on to the next step, which could open a whole can of worms. So something to consider, you might want to have a cap on the amount that investors can invest. So now that you've answered the first question, you are a covered person. The next question is, are you subject to disqualifying event? So the SEC, the rule lists out certain events that could subject you to being disqualified. So certain criminal convictions, certain court injunctions and restraining orders, final orders of certain state and federal regulators, certain SEC disciplinary orders, certain SEC cease and desist orders, SEC stop orders, and orders suspending Regulation A exemption, suspension or expulsion from membership in a self regulatory organization like FINRA, and US Postal Service fraud. Those are the categories, right? So, going through them, the criminal convictions and court injunctions, those are all related to fraud or lying about selling securities, right? So it's not all criminal convictions, right? So if you've had a DUI or something like that, that doesn't count, right? So it has to be related to the purchase or sale of a security, or making a false filing with the SEC, or involved in the business of underwriting broker dealer, selling securities, stuff like that, right? Um, SEC disciplinary orders are pretty self-explanatory. Usually, what happens if the SEC engages in an enforcement action against someone and they, have a disciplinary order against a person, they'll straight up list it out there that you are barred from participating in a Regulation D offering or barred from raising money. So an example is, I don't know if you guys remember, but a couple years ago, Elon Musk tweeted out that he was going to take Tesla private. And the SEC got pretty pissed at that because, I mean, that's, market manipulation. You shouldn't be tweeting that stuff out to the public, especially if it's not necessarily true. That could constitute fraud. So they enacted a enforcement order against him, fined him a bunch of money, I think millions and millions of dollars. And part of the order was that he potentially could be barred from conducting a Regulation D offering in the future, which, that has huge ramifications for a company like Tesla. If you're looking to raise money privately and you can't use Regulation D, that's a huge roadblock. So something that he had to deal with. Yeah, so those are the disqualifying events. But there is an important date to keep in mind, right? So when they passed the law in 2013, they didn't make it retroactive. So if those events occurred prior to the enactment date, which was September something 2013, then you weren't disqualified. You only had to disclose those events to your investors. So if it happened before 2013, even though it's a disqualifying event, even though you're a covered person, you're still fine. You can still do your Reg D offering. You just have to disclose it. But if the event happened after 2013, then you are disqualified. Uh, but so far as the disqualifying event is still in effect, right? So normally in a criminal conviction, um, there'll be an order by the judge, or there'll be like a sentencing. Like, you go to jail for how many years? Well, in the same order, there'll be guidelines on how long you will be barred from taking part in raising money. Same with SEC disciplinary orders. They'll say you are barred from um, raising money for X amount of years. That time period is how long you are disqualified for. So it's not forever. Even if you have been subject to a disqualifying event after 2013, you can eventually still do Reg D offering once that period is over. So 5, 10 years, however long it says in the order, that's how long you have to wait. And then after that period ends, you can raise money, but you need to disclose it when you do. When you send the PPM out, the PPM needs to say, I was subject to this event in the past. Yeah, that's about it. I mean, pretty self-explanatory. Two questions basically: are you a covered person? Officer, director, manager of the company selling securities, and then two, are you subject to any of these disqualifying events? If you are, then unfortunately you can't take part in this Reg D offering. So, hope that answered your questions about whether or not you are a bad actor. Um, as always, today is Thursday, so that means we got another episode of TLG Talks with Gene interviewing a person in the industry. I think this week is going to be Lynn Murrow, actually. So she is, I forget her title, but she's pretty high up in Lifestyles Unlimited, a group out in Houston, Texas. We have a lot of clients that come from them. So I'm actually really excited to hear from her because she is their basically head of legal, right? So she's in charge of making sure that the people in their group are doing things in compliance with the law and with their rules. So actually, I'm kind of excited to watch that one. So go check that out. If you missed our rookie camp, it's going on right now. So what am I doing here? You might ask. We will probably do another one later this year. We're not sure on the exact date, but keep an eye out for that. If you have any questions, reach out to us here on Facebook, LinkedIn, or you could go to our website, trowbridgelawgroup.com, and schedule a free 30-minute consultation with either myself or Gene. Thank you for tuning in. Hope you guys found this informative, and I'll see you guys next week.